ZEBRANEK versus Board of Osteopathic Medicine.
May it please the Court, my name is Shannon Macklin Carlisle of the Carlisle Appellate Law Firm, and I represent the appellant James ZEBRANEK. Judge Griffin, I'd like to reserve 5 minutes for rebuttal, please.
I'll try and help keep you time.
Thank you. Your Honors, I think this will be one of the most interesting oral arguments that I give because during the course of the two other arguments this morning, opposing counsel and I went to the library and discussed the case at length, and I think that we've come to the conclusion that we agree on about 99.5% of what this court should do.
Okay, I'm making a note that you're my favorite two appellate lawyers of the month.
The situation, Your Honor, is that...
What don't you agree on? What is our job now?
Well, I think that what we do agree on is that Mr. ZEBRANEK should be afforded a hearing, an opportunity to establish both that he was not on notice of the final order and also if he is able to establish that fact, that he should be permitted to bring a situation alleging that the petition, that the final order should be rescinded because it was based on fraud. The situation here is that...
So does he have to file a new petition alleging he didn't get a copy of the original order?
That's where we differ, Your Honor, is that opposing counsel believes that your court should affirm the board's decision without prejudice for him to file an amended petition. My position, and Mr. ZEBRANEK's position, obviously, is that on what we have here is a pro se litigant going before the board and alleging that he did not, that essentially fraud on the tribunal, that he did not receive the voluntary relinquishment, that he never signed the voluntary relinquishment, that this is not his signature. The signatures on both the voluntary relinquishment and the petition do not match on the face of them. Number two, the final order demonstrates on its face that it was sent to Mr. ZEBRANEK at an address that was not his address and was not the address on record. And so it's our position that based on the face of the petition that alleged sufficiently fraud on the tribunal and on the certificate of service that shows that he did not get the final order sent to his appropriate address, and with the facts that the board was on notice that he was actually in Romania during the time that this final order was entered, that the board should have determined that it had jurisdiction to go forward with his hearing on the fraud allegations.
Well, let me ask, with regard to the fraud allegation, though, if he got the order a week after it was rendered and 10 years later he brought an action to set aside on fraud, would you agree that maybe that's too late? I mean, isn't the real issue whether he had to act after getting notice of the order, and did he get a copy of the order?
Right. Yes. The issue in this case is, did he allege sufficient facts that did the board have jurisdiction to determine jurisdiction? And the opposing counsel cites to the Reich matter, which said, to state that the board acted appropriately, and that opposing counsel's position is that the petition, on the face of the petition, had to allege sufficient facts. But if you turn to the Reich matter, Your Honors, the petition was brought, it was a motion to vacate in a final order because the appellant never authorized his attorney to accept the terms of an agreement. But then what it says is, however, at the hearing on the motion to vacate, appellant said he didn't know until a certain date.
Okay, so help me out here, because I'm not exactly, maybe make it clear to me, what is it that you're asking us to do?
We are asking you to reverse the order that dismissed for lack of jurisdiction and remand for an evidentiary hearing on the fraud allegations, which is...
Can't y'all just settle this and
Your Honor, that brings me to another point, in all honesty. I am somewhat flabbergasted that this morning, on the day of oral argument, I learned for the first time that the other side agrees that he should have a hearing, because that is all we have been asking for over a year.
Well, you're only entitled to a hearing, would you agree, if your client didn't get a copy of the order? In other words, if he got a copy of the order 1 week after, regardless of whether he was in Romania,
exactly,
he needed to act. Now,
and my client was ready, willing, and able at the hearing to testify that he didn't receive the order.
Right. But his petition doesn't allege that he never received the order. I mean,
right.
You know, you can argue that it's a different address than what was in the record. You can argue he was in Romania,
right.
But he never says he didn't get the order.
And my position is...
Well, but if he says, if he does an amended petition and says, I got the order, I never got the order, then is it any difference in the remedy, you know, whether we affirm without prejudice for you to amend the petition and make it clear, or reverse for a new hearing? Is there any difference between the two?
The difference is 13 months of painstaking struggle on behalf of my client to try to get the board to do exactly what you're saying.
But it happens either way, right?
What happens is...
I mean, if he'd have just alleged, if he just made sufficient allegations, he wouldn't have this problem. So it's not necessarily, it's not the board's fault that he...
And once the board gave him a hearing and he was right there, and what I contend that the court erred, or the board erred in doing, was just dismissing it for lack of jurisdiction without any sort of opportunity or enabling him to amend, to allege that, or also to ask him, he's there at the hearing with all of his witnesses, to say, okay, you were saying that you didn't get the voluntary relinquishment, you were out of the country, the face of the order shows that it wasn't even on the right address, did you get it? He could have said no right then and there, and we would not have been here. But this pro se litigant was doing the best he could. He alleged...
So specifically, what is your point of disagreement then?
The point of disagreement is...
Between the two of you.
And again, I'll give...
Okay.
You want us to reverse, he wants us to affirm, and...
I want you to reverse and remand with instructions to permit him to have the evidentiary hearing on the fraud allegations.
But you both agree that there should be a hearing, right?
I believe so.
And you're going to go back and you're going to amend your petition, I assume, aren't you?
The petition already... our position is that the hearing should be about fraud, that he alleged that on the face of the order it shows that he didn't receive, that the board did not send the notice to the appropriate address.
Well, if he got the order a week after it came out, should he be entitled to hearing on fraud years later?
No.
Okay. So I see the fraud issue as kind of a red herring. To me, the issue is whether he got a copy of the final order. Now, and the problem with what you're suggesting is, how do we know, if your client doesn't allege that he didn't get a copy of the order, how do we know that? In other words, if we say have a hearing and your client comes in and says, well, I got notice of the order a week after, but I just figured I'd wait.
Well, I assume you want to amend to make that allegation, and so you can show that, right? I thought that's what you were trying to do to begin with.
Yes.
Well, you didn't allege it. You didn't allege it in this petition, though.
But my point is
okay, go ahead. I'm trying to understand.
That board should not have just dismissed for lack of jurisdiction. They didn't even let him, he didn't hear him out as to why they had jurisdiction.
Well, it sounds to me as if opposing counsel agrees with that, and that makes some sense. If the two of you can't agree to whether it's a reversal, I mean, it seems to me that it's very difficult for us to reverse under the circumstances. And an affirmance it could be a problem for you. So could the two of you agree simply for the court to relinquish jurisdiction, for the proper allegation to be made, and for a hearing to be held on the limited issue of notice?
We actually
Do you agree with
discussed
that?
We haven't heard a word from you.
Do it.
Feel free to
I've been
speak.
very patient. I've been.
All right. Well, let's just have you sit down for a second
I'll reserve my time and
hear
let him-
from
let you all-
rather than characterizing what he thinks. Let's hear what he thinks and see if we can't resolve this. And if we can't, then we'll press on. Go ahead.
But can I just add one thing, and the main point that I'd like to have you all keep in mind, just the practicality of this situation. When we filed a notice of appeal because we were dismissed for lack of jurisdiction 13 months ago, and now we have ad nauseum just tried to get the hearing on exactly what you are saying, and it has not been able to be done. And so to have this happen today is
a wonderful thing from your standpoint. So stop complaining. Sit down.
May it please the court, my name is Gar Chisenhall, and I'm appearing on behalf of the Board of Osteopathic Medicine. I'll just cut straight to the chase. How I recommend this case being resolved is that the order on appeal be affirmed without prejudice, the appellant amending his petition to allege when he received notice of that 2003 final order. Because before we get to the part about fraud and potentially rescinding that 03 final order, we've got that jurisdictional hurdle to get over.
Well, let me just tell you that the problem conceptually that I have with that notion is that affirming without prejudice is a little bit of an alien concept to me. You know, the parties have gone through and they've done the best they can. They present us an issue on appeal, and we've got one of two choices, but affirming and then saying, but it's okay for you to go back and try this again is a little bit tough for us, which is why I was suggesting that if the two of you agree, as we sometimes do, to relinquish jurisdiction, go down, if you agree that he's entitled to a hearing on the limited question of whether he had notice, then go back, have your hearing on that limited issue, reach a determination, and then it can come back up here and we'll have a record on which we can make this decision. Now, you're entitled to do whatever you like. If you'd like for us to just press on and make a decision, we will. But that's the problem.
Right, I understand. And if I remember correctly, under 120.569, the appellant could have amended the petition any time, at least once. I understand where the court's coming from. I understand why it has some heartache about affirming without prejudice.
I mean, is there any problem with just remanding for a hearing on that limited issue?
I don't believe so, and that's where I want to be very careful, and that's where our potential disagreement lies in what kind of hearing, what would happen. And as I said before, we've got this.
What difference does it make if it's an affirmance with, without prejudice, or a reversal? You're going to have a hearing, and if the issues are specifically defined as what you're going to have a hearing on, and the two of you agree with that, what difference does it make?
It probably doesn't, Your Honor. It probably doesn't. It could come out either way.
Let me ask you this. Are you willing to agree to ask the order relinquish jurisdiction with 30 days for Mr. ZEBRANEK to file an amended petition alleging that he did not receive timely notice of the prior order?
That sounds fine, but the one thing is that we still have a question about whether he can truthfully allege that, that's still an open question, whether he can truthfully allege that he didn't receive.
Well, that's why you just want to require him as a predicate to this to to amend that petition and put his signature on it.
Correct.
Because then that's where the rubber hits the road for Mr. ZEBRANEK.
Exactly. He's made all kinds of allegations, but he's never said that I didn't hear about this order until after my time for filing an appeal had expired. And, again, I want to be very clear about this hearing, is that the hearing should only be on this jurisdictional question about when he received notice.
I think we all agree with that.
This whole thing about...
Not Ms. Carlisle?
When he got notice?
Are you agreeable to that type of stipulation of that type of order?
Should I wait till he finishes before I respond, or can I just... My problem is that we have waited 13 months and many thousands of dollars in attorney's fees to get the result that I asked for 2 weeks after we filed the notice of appeal.
Doesn't matter. Do you agree or disagree? You want your hearing or not?
I want the hearing. That's what I've been asking for.
Okay.
Well, and just...
Limited issue of when he got the notice, and that's it. He's going to go back, amend his petition to make the allegation if he wants to, and then it will be up to the hearing officer or the trier of fact to determine whether his allegation is actually true or not. And that's it, just that one issue.
And if, assuming that he can, which I personally believe he can, make that allegation, then that would enable them to issue a new final order that then is appealable based on the fraud issue.
Well, we'd relinquish jurisdiction. We'd relinquish jurisdiction, and the issue of notice would be determined.
Yes.
That's what you're entitled to a hearing on.
That's
at this
why you
point.
wanted the affirmance with, I see now. Okay.
Right. Yeah.
Well, just forget about all the fraud allegations. If he can truthfully allege and prove to convince a DOA administrative law judge that he didn't receive timely notice of the order, then the board does have jurisdiction. And all the fraud stuff has no part in the notice thing. And then, see, I think our disagreement before has been about what kind of hearing he's entitled to. And I agree that if he can amend his petition to allege he didn't receive timely notice, then he only gets an evidentiary hearing on the notice issue. Now, if he can convince the LJ they didn't receive timely notice, that's great. And then we have all the stuff about rescinding that 03 final order or figuring out what to do then. That's a whole other ball game right there. And
Ms. Carla, I agree with everything he said. If the two of you believe that you can come up with a stipulation for relinquishment of jurisdiction for that purpose, then I, at least among one of three of us, and we'll decide between us, I would agree to do that.
I would agree too.
I agree.
But I don't want to have the two of you leave here with him losing his opportunity to get an affirmance and find out that the two of you can't agree on what seems to me to be fairly basic.
I just want to make sure that, assuming we have this evidentiary hearing,
Yes.
and assuming that the facts demonstrate and an ALJ determines that he did not receive notice of that final order.
He did not receive timely notice.
He didn't receive timely notice of the final order in time to appeal it. That the remedy is then a new final order is entered, and then he has the opportunity to contest that final order.
Well, he wouldn't contest it because he won it.
Yeah, but that doesn't make any sense.
The first hearing is going to be on notice.
Why would he contest an order that's in his favor?
No, the
You mean below?
The order that was based on that.
Okay, I got you now. Okay, I see now.
Well,
If there's a final order, and then that enables him to appeal within 30 days this order that that he says I wasn't even a party to it. So
Well,
therefore it should be rescinded.
You'd actually have to file a motion. I mean, if your client alleges that he did not receive notice, and if that's so found, then I think you'd have to file a motion then they issue a new order. I think you would have to file a motion to set aside as based on fraud and then have another evidentiary hearing. On the other hand, if they found that your client did get notice, then there's no reason for the second hearing. You can appeal that
Yeah, but so she wants to guarantee she's going to have a hearing, automatic hearing. That's what.
Well, I think, don't you agree that if the ALJ determines that he didn't get timely notice, and that there is jurisdiction, then there will be a hearing?
Well, there will be something. I mean, then it will be teed up for the board to decide.
You'll be back to square one.
Correct. Yes, ma'am. And there's a lot of issues about, you know, one thing I'm very concerned with, and this is why I definitely have to draw my line at rescinding the order at this point, because osteopaths have to renew their licenses every 2 years. They have to maintain continuing education requirements. They have to, you know, keep their license active and good standing. And so the board doesn't know what has been going on for 5 years. So once we get past the jurisdictional hurdle, like I said, there's a whole other ball game beyond that.
And so everybody can have a hearing on which all of these issues get determined.
Once we get past the jurisdictional thing
Right.
and get that resolved, then he can file a new petition perhaps, or they can take up the amended petition, but then we'll have to figure out where to go from there. That's going to be pretty complicated.
If they prevail on the lack of notice issue, then everything's back to square one.
Yes, Your Honor, yes.
Then if you don't prevail, then you want to be able to appeal that again up here? Is that right? If you lose again the ALJ says that you didn't get timely notice, then is it your intention to want to appeal that order as well? Because then you'll be out anyway.
Well, if we're relinquishing jurisdiction and
But that's, I don't know that they've
if
agreed.
we relinquish jurisdiction and there is this hearing, then I presume whichever one of you does not prevail, if you want to, you can come back up here, and that issue will be determined, because what we have before us is an order on lack of jurisdiction.
See, that's
the only thing that'll come back to us. If one of you, still wants to fight about it, and then we'll dispose of this case with the benefit of that evidentiary hearing.
You didn't want that. You want it now?
Well, can I just have to get some clarification? So let's say that we go back to DOA, have an evidentiary hearing just on the issue of when the appellant received notice of that 2003 final order. And if the administrative law judge determines that he did not receive timely notice, then we go back to square one, and his petition, his amended petition, will be then before the board. Then we have to decide where to go from there. But if we have an evidentiary hearing at DOA on the notice issue, and it turns out that the administrative law judge rules that he did receive timely notice, then
she wants to appeal it.
Then it comes back here.
Mm-hmm.
Then it just comes back here.
It comes back here. Yeah,
it comes back here, and y'all can file amended briefs. Same thing would be true of you as well. Whoever loses on this notice issue, if you felt aggrieved by the administrative hearing officer's decision, then you can come back here and we'll decide the jurisdictional issue with the benefit of that transcript, whoever wins or loses. If either one of you wishes to review it. If not, then you go ahead and you conduct the full hearing, or he goes away, depending on what the decision is.
That sounds pretty good to me, but I just have one more detail I want to put to the court, and that's in terms of recommended orders and final orders. Usually administrative law judges, their jurisdiction to issue final orders is pretty limited, like in rule challenges. I'm just wondering, I think perhaps the administrative law judge would issue a recommended order and maybe the board would do the final order. I'm a little...
Well, that sounds right to me. If it turns out that this can't legally be done, then come on back. But I just find it hard to believe that DOA can't provide you with a hearing officer that can take evidence and y'all can arrive at a legal determination with testimony, with evidence, as to whether or not this gentleman ever got notice of this hearing. And I think that sounds like a good resolution. And if y'all want to offer us a stipulation to relinquish jurisdiction in the next 10 days, then we'll be happy to entertain it.
I think that's a good idea, Your Honor.
Yes, Your Honor.
Okay, good. Then we won't have to talk about things that are probably going to be irrelevant once you all go and have your full evidentiary hearing. So unless there's anything further, we'll excuse you and we'll look forward to the joint motion for relinquishment that hopefully will not be too complicated.
Thank you very much.
And this is all, by the way, archived, so you can go back and look at the oral argument if you have any question about what we're thinking. Thank you very much for your working this out. I applaud you both for that.